big picture, what do you think of first when you hear about gaming patent litigation? Katie?
I mean, I think of like large NPEs, essentially, that, they acquire a lot of patents. They come to large companies and they want a settlement, or they're going to sue you. So, I mean, this is just based off where I am in the market. Like, we get a lot of people that come with, infringement letters. Some are, a little bit more substantive than others. But it's a big problem for us. Is just, here's this patent, you probably infringe, or here's this portfolio, you probably infringe. Pay us or we're going to sue you. And just having to deal with that on, a daily basis. Probably not daily, probably a couple times a month. But, for large companies, it's definitely a problem. So those are what I would more traditionally think of as, a troll. And again, some of them are not trolls, right? Like, they might be legitimate patent owners that are asserting something, and it's hard to tell at first blush which one you're dealing with. I brought the story last time of I actually got mailed a 900-page binder that was filled with patents, and there was just a cover letter that said, like, "Dear Miss O'Sullivan, you probably infringe one of these. Like, here's my terms." So that one I do think would be considered a troll.
Yeah, I mean, I think that's a bit. I mean, you can't say, "Oh, hey, I think you owe me money because I think I have a right that I think you're infringing." I mean, that gets you nowhere.
A lot of them are like that.
That and $5 gets you a coffee from Starbucks, right? I mean, that's crap.
What Starbucks are you going to?
Yeah.
Well, maybe the small one, right? Yeah.
I mean, you'd be shocked by how many are that minimal, like 1 to 2 pages of, I have a patent in this space, you're in this space, like, give me a call. And then they want to enter into technical discussions, and they're coming in with like a low level, usually like a low level, like $5,000 to $10,000. But then it's like, okay, I'm not going to pay you. And then the next one comes in 2 weeks. The next one comes in 2 weeks. The next one comes in 2 weeks. And so you have to take kind of a stand as a company, right? Of, we don't pay these. We will talk to you. I will say our company is very good. We do look at everything that comes in. Like, we do take it seriously because you're on notice once you get the letter or whatever. Doesn't mean we're going to reach out to you if you send me that 900-page binder. You're not going to hear from me unless you sue me. But if you send us something and we're concerned, we might actually enter into discussions with you.
Okay, and we'll come back to that and like what that looks like. How do you get a company like yours to take it seriously and to talk? Ben, your preliminary thoughts.
I tend to define these things by conduct and not just, well, you're a non-practicing entity and you're trying to get a license fee or something like that. And I guess I should preface by saying probably half of my work is plaintiff side, half of it's defense side. So I do a fair mix. I view it much more as bad actors in general are people that are trying to either delay or inflict unnecessary litigation costs just because you can. And over, like an example, I had a case, plaintiff side case for one of my big clients, and a competitor that they had wanted to do an early summary judgment motion, hadn't mentioned anything about it in the 26F conference, and they wanted to do it over a term that in these consolidated cases, everyone was saying needed to be construed. And they wanted to do the early summary judgment before claim construction. And it's just like, what is the point of that? Everyone says it wants to be construed. We say it means this. You defendants can't even agree on what it means. We're going to have to spend a tremendous amount of money opposing this, and it's going to get denied, and it's useless. And you are just doing it because you want to run up the cost. Yeah. And I mean, I got on a meet and confer about scheduling it, and they had 3 equity partners on a call with me about scheduling them doing this motion for summary judgment. And I was just like, what are we even talking about here? And I see it a lot of just things that you're not going to win, but you can have a fight about it, and people have fights about it. And
well, I'll come back to that. Yeah. I want to get everybody's preliminary thought. Okay, so good, great. Ben.
Yeah, so I think from my perspective, the way to summarize it, both on the plaintiff side and the defense side, is a lack of understanding about the gravity of what you're doing. If you're a plaintiff, if you don't understand the harm you're inflicting on a defendant who's dealing with this stuff all the time, who's losing sleep over letters that the plaintiff never really intends to pursue, I think a lack of understanding of the gravity of what that does to a public corporation especially is a problem, because you're kind of misusing a power you have as a patent owner to disrupt a business when you shouldn't, right? So I think on the plaintiff side, not understanding what the defendants go through when they get these letters and the quantity of letters they get and how big of a problem it is outside of your one case is a problem, because you're looking at the entire dispute through the wrong lens. From the plaintiff side, I think the same can be true if a defendant doesn't engage. At Ridge, we are more often a plaintiff, and our defendants are normally ethereal Chinese companies that don't show up. And so it can be frustrating when they don't show up, they default, we ask for final judgment, and all of a sudden they show up. So it's a thing where a defendant not engaging in the process, which is, in our situation, typically a real, meaningful dispute, a business dispute with a competitor, means that we waste time, courts waste time, dockets are busy, we pay experts, and the right result is usually still achieved, but it's not done with any kind of efficiency. So that's my frustration, is when either side doesn't appreciate the gravity and sort of what it means to be involved on either side as a patent litigant. Okay.
So let me ask, I'm going to try and clump together what the two Bens have said here. It seems to me that in each of the cases that you've identified there, each of the scenarios, at least on the one side for Ben Weed, that early intervention and active management by the district court would solve this, correct?
Absolutely.
Would you
Yeah,
agree?
no, 100%.
And I suspect you're not seeing that.
Not everywhere. Some places it's better.
You're not. I think some places it's better. I think where a lot of the mischief happens is in discovery. And discovery is just, I lovingly refer to it as the monkey S fight. And judges just don't want to, and I don't blame them, they don't want to get involved in that. And, in the Central District of California where I practice, it's all dealt with by magistrate judges. And I think that's a place where there was just much more active management of that, and actually by district court judges, and just sort of laying down the law of what is just not acceptable. Because I think part of the problem is, and this has come up in sort of the damages things, it's hard to have a meaningful negotiation with somebody if you don't have an understanding of what sort of like the general baseline or where sort of a constellation of, well, this is where we should be around. And if you don't have a good sense of that, you can't have a negotiation, because you're going to have one side way over here and one side way over there. And I had a scheduling conference with a judge a week and a half ago, and we have some foreign Chinese DJ plaintiffs, and they're trying to fight having to bring their clients to the Central District of California for depositions. And I was trying to get the judge to just give us, a sense based on the case law that says if you're a plaintiff, even if you're a DJ plaintiff, you got to bring them to where you filed lawsuit, because it's really hard to have the negotiation about, well, where should we be, if their point is, well, we need to do it in Macau or Hong Kong, and we're saying no, it needs to be here in California. Like, you can't bridge that gap without somebody coming in. And I don't think that there's enough across the board sort of intervention to prevent a lot of this stuff.
So, and we talked about this specific issue during the pre-call, right? And I've thought about that. It seems to me that if you file a lawsuit somewhere, then you have to provide the witnesses. It would just seem that makes a lot of sense. And is it that, like, with a problem like that, is it the district court judge just, one, doesn't want to get involved in the discovery issue, which is probably always the case. But then two, if they do have to get involved and they have to say, come on, you're the plaintiff. I'm not going to make the defendant fly halfway around the world. Are they not issuing sanctions as often as they should?
So I think the problem in this instance is to get somebody to, I brought it up at 26F conference because I was trying to get a sort of just a back of the envelope from the judge. inexpensively on, you know, what do you think? And there are some districts, like I believe District Delaware still has the rule that the default is depositions have to happen in Delaware.
Right.
And, you know, having a default like that is great, because then you know where the starting point is. And if you want to have a negotiation of, well, we don't want to fly the person from China, or they can't get a visa right now to come in from China, okay, then, you know, we can make an arrangement. But you got to understand, I'm giving up a lot as the party that's going to agree to do it somewhere else. And, like, it's not going to be on China time, the remote deposition, you know. And so I think the problem is, though, to get an official ruling from a judge on a discovery issue like that is probably $40,000 minimum. And, you know, that's not an insignificant amount of money for a client to have to pony up to get an answer to a question that is as basic as, you know, I think your inclination is right, and the case law supports that. And even for a DJ plaintiff, the law says, well, you decided to file the lawsuit, you got to bring the witness to where the lawsuit was filed. But bad actors know that they can end up costing somebody $50,000, $40,000 to get that determination. It's like, well, do you really want to be spending $50,000 having this stupid fight?
Well,
Okay, go ahead.
yeah, just so back to my first point, which is I don't think litigants respect what it means to bring a lawsuit. Before COVID, this wouldn't have been a discussion.
Yeah.
The witnesses would have been here. And before COVID, every deposition would have been in person, and you wouldn't have had the option, which I think a lot of judges like, the option of, you know, Zoom depositions or hearings or whatever. But I think it was an important part pre-COVID of bringing a lawsuit that you were going to be committed to the costs and expenses that go along with that, either as a plaintiff or a defendant. I think post-COVID, the respect for the gravity of what goes on has really fallen off, and to the detriment of settlements, to the detriment of the quality of advocacy, frankly, the quality of presentation of evidence. I just think it's been a real problem, and I think that's what you're seeing there. And I think the judges don't really want to get into those kinds of issues, because you're probably have a status conference before a criminal sentencing in Central California, where they think a lot more, you know, longer and harder about it if they're not in a standard patent jurisdiction.
So let me ask you, Ben, are the judges that you see, do they really let these foreign corporations default, and then just on the eve of the entry, then they show up and you got to start over from scratch?
Yeah, I mean, think about it from the judge's perspective. If they're going to issue injunctive relief in the form of a permanent injunction, that's a pretty heavy kind of relief, and they give defendants a lot of opportunity to show up and say, hey, hold on a minute, we shouldn't get this injunction.
Yeah, but I mean, do they just not realize that this is a game?
The judges?
Yeah.
No, they understand. They understand, but I think it's especially weighty for them when you're talking about injunctive relief, because you're saying you can't do what your business is. And it's especially if there is no appearance by the defendant, it's sort of an almost ex parte injunction, which is even more difficult, I think, for judges to get their heads around.
See, this is just infuriating to me, you know, because it's a game. They're not showing up on purpose. And we all know that, right? And especially when it happens not just one time, it happens over and over again. And yet, so this is just unacceptable. I mean, the more I learn, maybe I don't want to know what's really going on out there. All right.
I mean, I'm more surprised that they show up.
Eventually, they'll sometimes show up just to delay.
I mean, my reaction would be, yeah, they don't show up, and then they just you know change their address on the paperwork of the company and run into the same building out of China and run the exact same business, just with a slightly different name. And
no, it's still, I mean, it's still whack-a-mole,
Yeah.
but I think, again, we're in a very different space than you are, Katie, but a lot of times these companies, the biggest place where you can hit them is in their Amazon pocketbook, right? So if they have a bunch of inventory in Amazon warehouses and you take an injunction from a court to an Amazon lawyer and say, here we go, here's an injunction, stop them, all of a sudden they show up. Because now you've got their inventory, which they've paid for, and it is in this country, and they can't get it back without some kind of a settlement with the rights holder or, you know, a fight of the injunction. So that's why they will show up. I mean, if there's no inventory here, if there's very minimal inventory here, they don't care, and they'll do exactly what you say. But Amazon will not let them move inventory around from seller to seller.
Okay. Katie, so in the situation that you raised, you said you get that several times a month where somebody will just like send you like, okay, you infringed something, so pay me.
Yep.
Is it, so just so I understand, that's several times a month you get this blanket, you must infringe something, I'm not going to tell you what, but I expect you to pay me. This is as compared to several times a month you get somebody reach out and say you're infringing?
There's different flavors, I'd say.
Right. So how often, I guess, how often do you get like a more serious, like where somebody said, okay, here's a couple patents from our portfolio, here's a claim chart that we've put together, so that you see that they put some work into it?
I'd say of the ones I see, it's probably about half are, there's decent work. And
So that means
I will
that-
caveat that a lot go to a headquarters in Japan that I don't see.
Uh-huh.
So I know numbers, but I don't always see them. But the ones I see, it's about half.
Okay. Now, what happens with those folks who are just sending you, I own these 900 patents that probably don't relate to anything you're doing?
The 900 patents, nothing happened with that.
So
We just kind of ignored
Yet,
that.
not yet.
Not yet.
Not yet.
If someone sends a letter that has a decent claim chart, they've identified products, they've made an effort. We have a patent defense team at my company, and they will actually go through and do an analysis. They'll check it, they read the claim charts, they'll do like a whole-fledged analysis on it. So they take it very seriously.
Okay. And for the ones that are not, then do you hear from those people again? Do they ever wind up suing you, or is this just
Sometimes. Yeah, if we don't think there's a major risk, we usually won't respond. And then sometimes they do sue.
and where?
Normally Texas. That's actually fun, one thing we're seeing. And just a thought I had while this was all going on about bad actors. I think a lot of what you're seeing is like, don't hate the player, hate the game. I think we're just seeing people really learning how to utilize loopholes very well. Like I think you see trolls, everybody is just learning how to game the system. And I think I don't know if that makes them a bad actor other than they're just...
Oh, no, it makes them a bad
Yeah.
actor. I mean,
But
so-
it's like a...
So what I see,
Like
all
here's,
these, go ahead.
I have an example for you.
Okay, go ahead.
So, like when we do get sued, if we don't respond, they have something, they want to sue us. It's usually in Texas, right? So we're a Japanese company, but we have a U.S. subsidiary that's very large. It's in California. They will almost never sue our U.S. subsidiary because they want to keep it in Texas, right? So if they sue both of us, then we have a stronger tie to California, right? So we have a stronger motion to transfer. So then they get it to stay in Texas, but then we get into discovery and they argue that they should not have to go through The Hague or anything else because everything is available in the U.S. at our U.S. subsidiary. So
Who they didn't sue.
who they didn't sue. So that's a fun one I've seen a couple times now.
So now that I will say that maybe I don't like that perhaps, but I get why that is, right?
Yeah.
Is because the way that the Federal Circuit has evolved the law or devolved the law is there is no uniform patent law. There's patent law as it exists in Texas, and there's patent law as it exists in California.
Yeah.
And you as a defendant want to be in California, and me as a patent owner wants to be in Texas. And if you fight on your playing field, it's almost as if the law is different. The patent law in Texas is definitively different than the patent law in California. And maybe the patent law in Texas is definitively different than the patent law everywhere else in the country. That may be true as well. Which, makes me wonder whether we actually really need the Federal Circuit, because we could deal with, we had that chaos before, and it's, but, so I get that gaming seems like less of an abuse to me, because the system almost seems to encourage it. It almost seems to encourage it.
What I would say, though, is I think I don't disagree with what you're saying, that there is the patent law is applied. It's applied differently, certainly in Texas than it is in California. And even if it's not, it's certainly, there's proclivities in Texas versus California.
Mm-hmm.
Like northern of California, the likelihood of them granting summary judgment is dramatically higher than down in Texas.
Correct.
Or their willingness to do an early Section 101, I think, is much greater in California.
Right.
So I'm not saying that that's wrong, but I think even if everyone was applying the same law, you would still have venue forum shopping just because of the jury pools. There's a dramatic difference between
Right.
a jury down there. So it's not, I'm not saying that you're wrong. I just think that sometimes we talk about this, oh, there's forum selection, and it would just be solved if we had uniformity of the law.
but we've-
And I want to make sure we're not going towards like a unicorn that doesn't exist.
No, I get you. But we've always had that kind of difference in jury pools
Yeah.
and so forth. Where I have in my head, if you file in Texas, you very well may get a decision on the motion to dismiss before one of the judges down there decides on the motion to transfer. And then if that happens, then they do transfer it to California. Often, maybe more than often, almost all the time, the judge in California is not likely to revisit the motion to dismiss because, as Judge Rader has pointed out many times, judges don't like to say other judges are wrong. At least on the co-equal level, right?
Right.
A district court judge in one part of the country is not going to usually challenge a district court judge in another part of the country. That's what we have the tier with the appellate system for. Then there is significant advantage to filing in Texas. And so let me dial back one more and get you all to comment on all of this if you want, or any piece of it. But what irritates me is over the last generation, as we vilify patent trolls, whoever they are, whatever that means, what we have seen is that those people who are looking for the gaming of the system in a untoward way, I'm not trying to get a strategic advantage here for a legal reason. What I'm trying to do is I'm trying to string you out so you run out of money and you never get to the merits. I'm trying to make it impossible for you to take a deposition on my clients. I'm going to throw frivolous arguments up knowing the judge doesn't like to give sanctions so that you have to spend money that should be unnecessary. Those kinds of decisions exploit judicial inefficiency. So the judicial system in the U.S., maybe everywhere, but I'm an expert on it in the U.S. The judicial system in the U.S., I think, is set up to believe parties are not going to engage in abuse or untoward behavior, by and large. And judges don't like to presume that you are, and they don't like to issue sanctions. And like you say, oh, okay, I'm about to say death penalty for you. We're going to seize all your stuff. Injunction. So you can come in literally at the last minute with a sob story, and I'll let you do it again next week, right? And because we don't want to believe people are bad actors. The system is not set up, I think, to acknowledge bad actors. So what I have the problem with this whole patent troll narrative is it has devolved into it is a problem with the patent. And no, it is not a problem with the patent. If we did away with the patent system entirely, all of those people trying to exploit the judicial inefficiencies using a patent would move on to whatever's next and exploit the judicial efficiencies in real estate or the judicial efficiencies in contract law or in, you name it, insert area of law here. That's what they do. So what I'm trying to get at is what are those things that we need to point out are the problem instead of it being the patent. So I don't think it's a problem with these 900 patents, for example. What I think about it is each one of those patents that says what it says should be presumed valid. I think if you're infringing, you should be entitled to damages and you should be entitled to an injunction. The problem is you probably don't even do anything in any one of those patents, or if you do, it's because what you do overlaps with the title, which that can't be where we're at. So that's the problems that I see. A lot out on the table. Okay, so pick and choose whatever you want to deal with, and say what is safe for you to say.
Right.
Ben.
So I don't want to. I'm not trying to sound like a friend to the patent trolls by any stretch with what I'm about to say. But Ridge is an e-commerce company. We have a website. We use Facebook tools on the website to track people's usage of the website. We send text messages. We send emails to people who have opted in. The trolls in other areas of the law are so much worse and so much more shameless than in the patent space. There are people out there who sign up, their job is to sign up for SMS messages and then respond stop. And every time someone doesn't stop, they send a letter. We had one guy send a notice of opt-out of an SMS campaign by mail. He put a letter in the mail to us, to our headquarters in California during the pandemic. He used a service where he has a PDF copy of the letter and the envelope and then the certified delivery receipt. And that's what he sent to us. And we had an arbitration about it that lasted 9 months. And it was a snail mail letter trying to opt out of the text messages he had opted into the week before.
His phone broke, right?
No, it's that, and that's what he does. He does it all the time, and you can't find out how much he does it because it's all arbitration. All of these opt-in, contracts say you must arbitrate your dispute. So that stuff all is not public. So at least patent trolls have a patent. They've paid maintenance fees. They've overcome whatever rejections you had to get at the patent office to get the patent. There is a level of troll below what we know as patent trolls that I don't wish upon anybody. We'll settle these things for like $700. I mean, it's crazy how different it is and how shameless people are. So I think...
Well, and that's true. Like with copyright trolls. Have any of you ever dealt with copyright trolls? Okay. I mean, they are maybe not that level of scum, but pretty close.
It's bad. There is an old woman who has a reputation. She's like 70 years old and she's partly blind. And what she does is she goes to websites and finds sites where the background color is too close to the font color and says, well, I was trying to buy a Ridge wallet, to hold my driver's license, presumably, whatever. She's 70 years old. She's not a Ridge wallet demographic person. And she sends us an email or a letter saying, you're violating the ADA because I can't buy your product because the contrast is off. And so we pay her $800 and she goes away. And she does that for dozens and dozens of times a month. So it's just, I think it's human nature that if there are loopholes and ways to get rich quick, they're going to exploit them. So I think to a degree you can't get rid of that behavior. To your question, Gene, it feels to me like if people had more skin, if they had to have more skin in the game somehow, that would be, I think, a way to deal with it. So if the defendants had more skin in the game, if they were screwing around on discovery and there was easier paths to sanctions or fee shifting for tasks that you lose a dispute about, if plaintiffs had more risk of being financially on the hook for their shenanigans, I think things would be better. But a lot of times plaintiffs are uncollectible. So it's like, okay, sanction the plaintiff, what then? So I think it's a difficult problem. It seems to me that the answer to it is everyone has to have more skin in the game. And back to my first comment, people have to take it more seriously and respect what they're doing more. But I'm not saying a loser pays is right, but something like that where there's more skin in the game on both sides seems like it would be a more serious endeavor for both sides.
Well, I've at times liked the idea of loser pays, and I've at times not liked the idea of loser because you don't want to deter people from bringing what they believe to be an honestly legitimate claim. Yeah. But
they have a piece of property that they paid for and got.
There ought to be a situation, though, where the loser would pay if it's agreed. We could create a legal definition that would capture that behavior. If you are manufacturing the case to be brought next week and you lose, then you pay. There would seem to be ways to do it. And it's frustrating that it's not being done.
And just a quick, and not really a plug, again, a lot of what we do that's not patent stuff is arbitrated disputes. So one thing that you see there is that, like, if you elect to bring this dispute, number one, it costs a lot of money to file an arbitration. It's expensive for the fees, the costs of the arbitrator's time and whatnot. So you have to do it with a real reason to do it. And number two, a lot of the agreements that say thou shalt arbitrate disputes will also say the loser pays. So you go into that knowing by contract that if you're going to enforce that contract, you're going to pay if you lose. So that's kind of a nice thing. And then the arbitral award is not usually reviewable. So it's kind of like you're gambling. And if you win, great. And if you lose, it's over, kind of thing. So I think that is frustrating in some ways because, as I said, it's very private. But it's good in some ways because you know that once you're done, you're done. And everybody has the opportunity to lose and lose more than just their claims in the arbitration.
Okay. Ben, any?
I think that the sort of the rules of professional responsibility and the way that judges sort of view the bar came from a world where the law was seen much more as a profession than a job that it is now. And I think you're exactly right that the system sort of is very the last place they want to be is making a ruling that somebody has acted unethically or, shouldn't have been filing this motion. And I think that needs to catch up with the times, because I do think there's a lot of people that just submit stuff that's frivolous and should be dealt with, but they know that nothing's going to ever happen to them, so they go ahead and they do what they know they shouldn't be doing, because it's going to give them a little advantage around the margins, and they know there's no drawback. And I think having more sanctions or more aggressive fee shifting on lost discovery motions and stuff like that, I think that would go a long way. I mean, the one thing that I think has surprised me so much recently with all the AI stuff is the speed at which judges are giving sanctions for the improper use of AI. Or like there's these hallucinations happen and it's like 3 weeks later the attorney is sanctioned. And it's like that type, I mean, maybe that's sort of at the other end of the spectrum, but like I don't know what it is that's setting all these judges off about
I think
AI.
I can tell you what it is. They feel like they're being a fraud is being perpetrated on them.
Yeah, they're at risk of citing a fake case.
Yeah.
Right.
And that being part of
and
the
looking
rules.
stupid or looking bad, and which if they would do that with respect to just a couple. So, look, I'm not saying that we should behead these people and put their heads out on spikes like the Romans did outside of town, but that has a deterrent effect, right? The same way injunctions have a deterrent effect. Attorney's fees has a deterrent effect. Sanctions for abuse of discovery practices have a deterrent effect. So I'm not saying give these people the death penalty, but there ought to be consequences for this. And if you're not giving consequences, then you should expect that the people who are willing to act that way get the message that they're being encouraged or entitled to act that way. Yeah. So it's unfortunate. Katie, there's a lot out on the table. Pick and choose whatever you'd like to say or respond to.
Oh gosh.
Or start a whole new, is there another type of bad actor that you deal with or see?
So kind of just like on the flip side, I actually have a family member who is getting a patent. He works, has some contacts at like a big tech company, and he reached out to me and said, like, hey, should I put them on notice? I want to get into licensing discussions. Like, what would you recommend? And I think for me, like my instant reaction was like, oh my gosh, they can take you down in like XYZ way. Like, don't tell them till it's issued. Like, don't reach out to them. They're going to go take your stuff. And like just that reaction I had to like how bad it is and how hard it is to be an inventor and actually like go out and like have those discussions. I mean, I obviously see everything from the, big, large company side, but I really do feel for like the inventors who are trying to go out and get a patent on, like a legitimate invention and go out and try to license it. And he asked me, how do I do this? How do I get into licensing discussions? And I didn't have an answer for him. Mm-hmm. And I think that there's just something wrong with our system when that's the case. Right. Like when I'm like, you're not going to sue this tech giant, obviously. You're going to need millions of dollars litigation funding. You're going to need, years of backing. Like it's not going to happen. And so, how do I recommend something to someone in that boat? And the only thing I can see from where I'm at is when you have IP and you either make it a black box and you tie yourself to that IP, right? Like you are a service. So it's not like I can just buy your IP, but I need your engineers. I need your thinking. In those instances, you become more valuable than just your patent. And I think you're more acquirable, however you want to say it. Anyway, sorry, really random tangent. I know we talked a lot about, bad actors from both sides, and I've definitely seen it from the patent owner side, and I do feel for everybody who has to go through that.
I mean,
Ben, you've seen it from both sides. You were on the dark side right before you saw the light, right?
Which side is the dark side these days?
No, but now you're representing a patent owner who's got all kinds of, not patent trolls, just the dregs of humanity over in China, outside the country, trying to steal your business. Onesies, twosies, they open up P.O. boxes, they close P.O. boxes, they open up different names, all kind. I mean, and that's your daily existence. And before you went into that world, you defended.
Right.
Right. So what wisdom do you have? Do you have like like, have you stepped back to see like, well, what have I learned about both sides that I've seen front row?
Yeah, so I would say the thing that I've learned, so I was hired at Ridge to basically do all the litigation I was doing for them as a firm lawyer. There's nothing confidential to what we do. The financials aren't even that confidential. So there were no PO issues. There's no prosecution bar issues in the space we're in. So they hired me on a salary to do what I was doing at the firm as a variable cost item. And I think that gave the company a lot of flexibility because now I can deal with these $700, ADA violations, thinking about it as a firm lawyer would have thought about it. And they're not paying any more money for that because I'm already, sort of an employee. So that was unwittingly, I think, a very smart thing that the company did because they took what is a variable item and a thing where they're deterred from asking small questions. By bringing it in-house, they were able to get, real legal advice on all issues, even if it's just a first pass, let's talk to an expert kind of thing. And that has allowed the company to take the cost of doing litigation business out of the equation. So that's not an easy thing to do. But as a defendant, I know a lot of the big companies will have law firms on essentially retainers for a year, and they'll say, this case is worth 4 points, and you're giving us 70 points a year for our fee of $10 million, whatever it is. That's another thing where by having it be a fixed cost, you take some of the expense out of it on either side, and you can be more rational that way. I think that's the biggest thing is that getting both parties to be rational and saying, look, this is really what I want. This is what I'm likely to get. Let's see if there's a middle ground here early in the case. And if we can reach that middle ground, great. But I think the problem comes in when, either side has astronomically out of whack expectations and they can't be convinced of that fact at all. So whatever way a particular entity can have their expectations be realistic, I think that will help things. It helps manage what the likely outcome will be, and it makes it more likely to have settlements occur where they should.
Okay, so
can I
go
make
ahead.
it just back to a point you asked about before,
Sure.
which is how do we deal with this? One thing that we were kicking around before we came up here, and I have thought about it more as I was sitting here. In a lot of foreign countries, obviously, when you get a patent, you pay an annuity to keep it alive every year. And that means that every year you have to say, do I want to spend another $1,500 for this thing to stay alive for another year? Am I using it? Am I maybe going to assert it? In this country, obviously, the maintenance fees come up 3 times, but they're not usually that high. And if you miss one, it's very easy to revive a dead patent. So that may be a way where, to my earlier point about trolls that we see that aren't patent trolls, that don't even have an asset. They have a disability sometimes or whatever. That's the asset, or a willingness to shoot a shot 1,000 times and win 10. If you make the asset harder to maintain, then you're going to have more intention when it's used, and those that are not intended to be used will kind of go off into the ether. That may be a way, if you made it substantially, it would have to be, what does it cost, $20,000 to pay all 3 maintenance fees or whatever? If you made it big enough and had it an annuity rather than a 3-time maintenance fee, that might be a way to make sure that the patent owners are intentionally owning patents and not just sort of sitting on them and saying, oh my gosh, Apple launched this new technology. I have a patent that I could read on that. Let's go sue them. There's got to be more intention to it. That's one way that I just sort of kind of like more and more to keep the bad actors at bay on the patent owner side.
Any thoughts on solutions or other problems?
I think there's a lot of, over the course of yesterday and today, there's been a discussion sort of about systemic sort of policy issues that I think are problematic in patent law right now. And I think there has to be a new law that comes out of Congress that fixes a lot of the stuff that's been talked about. And the problem is, and you had touched on this, is, lobbying is a bad word. But the problem now is, like AIA, I think people can agree, that was pushed pretty heavily by big tech, and they got a lot of wins out of that. And, I think it's going to be interesting to see what happens with AI, because I think everyone in this room knows that a lot of AI is probably not patentable subject matter. And I think there might be an avenue for big AI companies to come in and drive a new bill and drive the lobbying costs to get a new bill done that helps level the playing field a little bit, to get something new done. Because absent that, I think big tech is happy with the way the system is right now. And as long as that's the case, they're going to spend a lot of money on lobbyists to make sure it doesn't change. And I think there's got to be a counterbalance that I don't know where it's going to come from, but I think it's necessary.
Yeah, there is no doubt that there is, even if Congress were interested in doing something, which I'm not.
Which they're not. I don't think they care about
I'm not convinced that they
patents.
are.
Yeah.
I know that a few members of Congress are very, very interested. But I just don't think there's enough people that are interested in doing something. But even if they were interested in doing something, in this climate with this administration, the America First agenda, what we had, the very first program this year, we had somebody on this stage who would qualify as a lobbyist, and they would say, you are not going to get this administration to do anything that they think is going to hurt U.S. companies and potentially favor foreign companies. So that then made me think, all right, so, and I don't know how to square that circle when President Trump talks about wanting, the FCC, the FTC, and others to go after big tech because they're abusing little tech. Okay, so what I think we need to do is spend some time to think about all the pieces that are moving and how does this fit, right? Because if the solutions are going to benefit Chinese national corporations, multinational corporations, and potentially disadvantage U.S. corporations, that's probably not a starter. Now, if it disadvantages big tech and advantages little tech, then maybe that has a lane that could be filled. But probably also not if it's disadvantaging big tech with employing huge numbers of U.S. citizens, helping little tech, but then also simultaneously helping foreign multinationals who are also U.S. patent owners. So there is a narrow selection of moves on this chessboard that get us a better patent system with stronger patents that benefit the disruptors that we talked about earlier. And I will confess, I don't know that I see that move. I don't in this environment. So even if we had partners in Congress who could deliver a movement on these bills, which I don't know that we do, and not to say anything bad about Senator Coons, Senator Tillis, or any of the others who are supporting this, I just don't think. I don't think that what they want, they can get enough people behind right now. And what I hear increasingly from people who have their finger on the pulse of what's going on in D.C. is that a crisis will clarify the mind. And we may not get much more before we have a real crisis, and that sucks. That's a technical legal term. So anything to say about any of that? And I know you're all not maybe experts in the geopolitics of this and all, but when you observe this from your lane, do you see a move that fits all the potentially moving pieces?
I don't think it's one move. I think it's many moves, right? Because you're talking about like so many different areas. You're talking about, better patent laws when you're doing prosecution. You're talking about better PTAB practices when you're doing, post-patent reviews. You're talking about better, court proceedings, these sanctions, things like that. And then you're talking about overarching policy issues. So I think you have to tackle all of those things, and you have to look at the issues with all of them, and they do all interconnect.
Yeah. So this was not a setup, but boy, that's a great answer, because what I've also started talking to some people about is that there seems to be a growing understanding that what we probably need is another 1952 moment. That's how we've been referring to it, where we try and take all of this holistically into account. And not that Congress is going to do that. So no, I'm not suggesting Congress is going to do that. What I'm suggesting is that we need to do that. We need to start that process and think about how are we going to be in a position that when the moment is right, that we have enough of this done. And I think we're going to take first steps to try and do that this summer and pull people together. So if you are interested in being a part of that, let me know, because I think you're exactly right. I don't think there is a move. I think there's a lot of moves, and it has to be almost like, you know, you're like calibrating things at a council.
I think that's exactly right. And I guess I should preface all this saying, before I went to law school, I did work in politics in D.C. If so, I know a little bit about some of this stuff. I still think even if you got, here's what everyone agrees should happen as like a broad policy thing, I still don't think you're going to be able to get it through Congress until you have a counterbalance of lobbyists coming in that are going to be pushing against people that don't want it. And so that's why I've sort of been thinking, what's the new technology that's going to come out that's going to want patents? And it's not going to be happy with the way the system works right now. And I think the one that is here is AI. Because I think everyone can agree that the likelihood of, you know, AI patents passing muster under Alice is basically zero.
Right.
And that might be what the impetus to get people to care on the Hill is the money from the lobbyists.
Yeah, it certainly could be, you know, and I do think that there's this feeling that losing the AI battle to China, who is probably, I'm told now we're maybe 6 months ahead technologically from China, and every time I hear that estimate, it gets smaller and smaller. It's only a matter of time before they're ahead of us, if they aren't in fact already ahead of us, right? And that will be something that a lot of members of Congress are not going to find acceptable for no other reason than that, well, we have to win AI. I don't think they know why we need to win AI, but they will feel that. And maybe that we can use that to our advantage.
And I think what we really need for all of this to happen is like a consistent roadmap of, when I hear these messages, all the things that are wrong, I think everybody can say they agree with this and this, but there are so many moving parts and so many things that intersect, and it gets complicated and confusing, even if you're in this space, to keep everything straight. If you had just like, I mean, I envision, you know, your 4 areas and like the main problems and, you know, the things that affect each side and like the solutions for those and how they intersect, and having some very coherent message that you could take to Congress and be like, you know, this is the fix for the patent system. It's these things, and like you've thought through, you know, the ways it addresses foreign policy and courts and all those things. I haven't seen something cohesive like that done.
And that's what I'm talking about. We're going to try and be a part of that solution and try and bring a bunch of people together from a bunch of different areas, including former judges, attorneys, in-house, outside counsel, maybe some experts, and really try and come up with a list of things that can be accomplished, that should be accomplished, and then why. And then have this at the ready, right? Because I think we're all right. I think we all kind of know that nothing. Even if we're right, even if we were to come up with, say, a dozen things that we all, whatever group we put together, thinks will make the patent system better. I mean, everybody agrees. It's unanimous. Nothing's going to happen until the people who own the patents are willing to spend money to convince the people who are the decision makers. And I don't think, and I'm not suggesting that there's payola here involved, because I don't think that's how lobbying works. But it costs money to be places where decision makers are and to make your case in a way that they can accept it and appreciate it. And hopefully tide will turn. So I just looked at the clock. We're over time, but I'd like to give each of you a quick opportunity to wrap up. Ben, we'll go with you first at the end, and Katie, you'll get the last word. Final thoughts.
Yeah, so the one thing I was going to say in response to what you just were talking about, Gene, which is when I was at the law firm, I was working with, you know, the Ciscos of the world, the big tech companies of the world as defense counsel. An area that I think probably isn't super well represented in this room right now is where Ridge is, which is kind of consumer products online, which is a lot of companies. There are a lot of smaller companies out there that do a lot of revenue online. And so that, I think, implicates 2 things that you were saying, Gene. One, what is a U.S. company? Are we a U.S. company? We have 50 employees here, but we make the things in China. So are we a U.S. company? I don't know. Like, what makes Renesas a U.S. company if there's a Japanese headquarters? I think it's a more complicated thing than just saying U.S. first, everyone else second. The other thing is, all of this legal framework aside, there are growing private arbiters of patent disputes out there, like Amazon and like Alibaba, who have their own private enforcement platforms, which don't adopt all of what you could do in a court. In an Amazon proceeding, you can't say a patent is invalid. If you're infringing a patent, they will take you down. The onus is then on you to go to a court and prove it's invalid. So whatever the law changes happen to be, I think, doesn't necessarily fix everything, because there are now these growing private arbiters of certain IP disputes that are not going to be bound to those laws. It's almost like arbitration. When you sign up to sell on Amazon, you say, I will be bound by your private IP enforcement program, and you can't complain about it if you want to sell on Amazon. So that's just another wrinkle that I think a lot of the sort of big firm lawyers who Ridge can't always afford to hire don't have a lot of exposure to, but I think it is an important part of the economy in this country.
Yeah, no, I agree. It's tough, like the first part, it's tough to decide who is a U.S.
Right.
company. That's got to be a real piece of this is, if the administration is going to have America first, fine. But I think we need to figure out, well, what does that mean? What does that look like? And I think that's what what the Federal Circuit may have been doing in that Lashify case, because it seems like Lashify, and I've said this, I'll say it again, but is essentially doing what Apple's doing. Ridge is essentially doing what Apple is doing. It's just Apple is so much bigger scale. But that bigger scale can't be what gets Apple to the ITC, and not the woman who's the owner of Lashify. That doesn't make sense to me. So, but great, thanks, Ben. Other Ben.
I'll just say quickly, I think everyone agrees that there are some major issues in patent law that need to get fixed, and I think it behooves everyone who, as their job, works in patent law to try and come together and figure it out for ourselves, rather than have Congress or other people come up with the solutions for us, because I don't think the solutions that are made for us are going to be ones that were probably great, and I just think it behooves us to try and come together, and I think we do have a lot of common ground, and we're going to be way better off if we can try and fix it or propose the fixes ourselves, rather than having them put down our throats.
Yeah, absolutely. Great, thanks, Ben. And Katie, the final word goes to you.
Just going off of what Ben down there said, a lot of these issues are very complicated when you get past the surface about like who's a U.S. company. Like for my company, the supply chain is incredibly complicated, right? Like how many different countries a chip touches and gets tested at before it ends up in an end product, and how that is impacted all throughout the chain and litigation. Like there's a lot of issues, and so I agree with Ben in the middle that you need patent attorneys and people that are familiar with these issues, that are in the room helping make these decisions, because we know all these things, we're seeing these things, and they're important considerations. And then the only other point I had, which I'm completely blanking on, I might not have another point.
Well, those were
I
two
think
really
that's-
good.
Yeah,
strong-
I'm going to say that was my last point.
Okay, yeah. And we'll edit out the third.
Yeah, that third point, yeah.
All right.